Number 49, the matter of Marian T. Let's just wait a moment until council clears out. Okay. Good afternoon, council.
Good afternoon. I'm Callan Connors-Brennan. I would like to reserve 2 minutes for rebuttal, if I may.
Of course.
This case involves the adoption of an adult woman who is not capable of providing consent to the adoption. We take the position...
Wait, how do we know that?
The respondent has...
Couldn't make a finding about that, right?
Your Honor, with respect, I believe that, all of the lower courts, both the trial court, the surrogates court, and the appellate division did conclude that Marian does not have consent, does not have the capacity to give consent for this. I honestly don't think that that's an issue on this record, and I think that, looking at the facts of this case, whether or not she has that capacity is not one of the problems before the court.
Well, this surrogate did an investigation, if you will, into that question.
There was some investigation done into that question.
There were experts that gave reports and
That's correct. There were 2 psychologists who did examinations and provided reports. The court also did do its own, had a meeting with, the surrogates court did have a meeting with respondent to assess for himself whether or not he believed she had the capacity to provide the consent. The guardian ad litem also offered an opinion that she didn't have capacity to provide consent. And she has been, for her whole life, diagnosed with profound intellectual disability.
Did I misunderstand the record? I thought Fox had said she had consented. Am I wrong about that?
Dr. Fox attempted to distinguish between her lack of capacity in all other areas and her ability to consent to an adoption. He attempted to say that although she lacks the capacity to consent to routine medical procedures, she does have the capacity to say yes if somebody asks her whether or not she wants to be adopted. I don't believe that his opinion was really worthwhile, and it wasn't explored during the hearing. Neither of the experts testified at the hearing. There was no direct or cross-examination of their opinions. I think the court essentially moved on after receiving those reports, and everybody agreed that, the consent issue was, her capacity to provide consent was agreed upon. She did not have that capacity. What the surrogate court then did was subsume her capacity, her consent into the best interest analysis, and then also seemingly accepted a consent on her behalf that the guardian ad litem actually never provided. So that it was the issue of...
Can I ask you a question about that? Because I know that's one of the main points of contention here is when the ability to consent is explored, or in what context. So it's a process, right? So if you say that ability to consent has to be determined first, okay? And again, this is assuming that the court can dispense with that consent. But then you have to go through this whole process, right? Whatever that may be, to determine her ability to consent, and then let's say the court finds that she doesn't have the ability to consent, and then moves on to the best interest. What difference does it make if it's all done at once, as long as the ability to consent is a required finding in the process? Why does it make such a difference whether we call it a threshold determination or whether it's just part of the overall determination?
Well, Your Honor, part of the problem would be that notice of the proceeding is only required by the statute to be given to those whose consent is required. So if the consent of an adult...
How could you determine if her consent was required unless you determined whether she was capable of giving consent? So wouldn't that presume some notice and some involvement of her and people around her who know?
So petitioners could submit an application a petition to the court for adoption, support it with the opinion of an expert and some documentation that the individual to be adopted lacks the capacity to provide consent, and ask the court to dispense with the consent and proceed without any notice or any further examination of the issue. They have, the court would have in front of it an expert opinion and other documentation supporting the fact that there's, this person lacks consent, lacks the ability to provide consent, and so we don't need to visit that issue. Let's move on to the best interest.
Well, so in this particular situation, she was in the custody of the state of New York, correct?
That's correct.
So does the state have to be given any notice?
Not under the adoption statute.
Well,
It doesn't.
How did she end up getting a lawyer?
I believe that she ended up getting a lawyer because the surrogate had never been faced with such a situation, had no idea how to proceed with such a situation, and had a good relationship with the mental hygiene legal service attorney who covered that area, and decided that he needed to bring her in and have her.
So would it arguably be an abuse of discretion not to somehow get the alleged incapacitated person to be heard in some fashion?
I think what is an abuse of discretion is dispensing with the consent of an adult. I think that's the ultimate abuse of discretion in this case.
Counsel, if she could not consent, and we can't dispense with consent, then anyone in this situation over the age of 18 could not be adopted.
If there's not an ability to provide consent,
Right.
and there's no way to, support their decision-making and educate them and get them to be able to consent, then no, they can't.
No matter what procedure, no matter the best interest of the child, there's just a bar. So if you start a petition before and the person's 17, but you don't get a ruling, they turn 18, you're done. It's over. You can't consent, you're 18, we dismiss. You can never get adopted.
Not under the current statute. This court would be creating a whole new statutory scheme to allow something
Actually,
like
we'd
that
be
to happen.
reading the statute in a way that you don't agree with, but I don't think we would be creating
How can
a
such a
scheme.
person consent to be in the care and custody of the state?
She actually was placed into the care and custody of the state by her biological parents when she was still a child.
So, but she never had the right to, when she became 18, to make a different choice, right?
She could have, she never did.
Well, how could she have if she doesn't have the capacity, the mental capacity to make that determination?
Well, it is a voluntary program, and people can sign themselves out. If she attempted to sign herself out and somebody believed that that was dangerous and that she lacked capacity to be able to do that, then again, the legislature has created a large statutory scheme in order to deal with this through guardianships. And practically anybody can bring a guardianship proceeding to try and protect the interests of a vulnerable adult, either under Surrogates Court Procedure Act 17A or under
So your red
Mental
light is
Hygiene
on.
Law
To be
81.
clear, very quickly, what is your position on what should have happened here? Since you're starting for the point that she couldn't consent, what should have happened?
The petition should have been dismissed. It couldn't go forward. She couldn't provide consent. It can't go forward.
Thank you, counsel. Counsel?
Yes, that's the worst of it. A whole class of people are excluded, people who are the most vulnerable, least protected, unable to articulate their own desires, not even ask. Marian wasn't asked if she wanted an attorney. Marian wasn't asked if she wanted to appeal her case to the appellate division. Marian didn't send me here. Marian hasn't. Marian believes that she should have the ability to be autonomous and make decisions, but Marian cannot articulate in a conventional fashion a consent, a legally cognizable consent, because she can't talk that way.
Can she communicate that in some other way? Are you saying she
Yes,
actually
she-
could consent, but just not verbally?
Absolutely, that's exactly right. Okay.
So then,
Which is what-
let me just, please, to clarify, is it your position that there was not a finding that she couldn't consent? Sorry for the double negative.
I draw a distinction, Judge,
Okay.
between the consent that she can give and the consent that the court was looking for. the court was looking for an understanding of the adoption process and what that meant. And Marian doesn't understand that, I don't believe. But Marian does very clearly understand the family that she's a part of, that she's been adopted into, what they mean to her, that she was very insecure when she was removed from that family by the state, who was in control of her life then.
Okay, so then is your position, and I think it's along the lines of what Judge Garcia was asking about before, that if an adult individual cannot give consent, right, given the nature of their disability, is not able, as you're saying with this description, able to appreciate what adoption means, therefore cannot really give a legal consent, that a judge or the surrogate should dispense with the consent requirement and move forward with the petition?
I think that's what the courts have concluded. They did take a convoluted route to get there. I'm not sure that that's required. But ultimately, if they determine that someone cannot consent, they can look all around at the other components of the decision-making process, the best interest of the child.
And if a judge chooses not to do that, would it be an abuse of discretion?
If the judge chooses to find no consent.
If the judge concludes,
says-
this person cannot consent, but I'm not going to dispense with the consent requirement, I'm going to dismiss the petition. Would that be an abuse of discretion?
I think without more, I think he has to examine
she,
the situation to determine what the best interests of the child are. Otherwise, you would have this automatic preclusion of the entire class of vulnerable
So you're saying
people.
under this particular factual scenario, a judge cannot conclude that they do not want to exercise their discretion in a way to dispense with consent?
I think the judge can exercise his discretion.
His or her.
To not dispense, his or her, to dispense with the consent requirement based on facts that he has to support such a decision. He can look behind the petition, as they did here, call witnesses, examine Marian, talk to the guardian ad litem. All of that was done here, and I think that is appropriate in determining the best.
Let me ask you a question, if I could. If Marian hadn't been removed from the home and there had been, I guess it was the Justice Center that did an investigation, is that right?
The state,
It was an agency of the state, I don't know which one it was. I thought it was the Justice Center.
well, what they call, the local entity of.
Okay. If that hadn't taken place, would we be here today with this adoption petition?
Yes, yeah.
Well, how
I
so?
hope we wouldn't be here. But we would have been in
Fair
the
enough.
adoption.
How would this have gone forward in the absence of
The
that?
adoption petition preceded the removal by the state component.
I see. Now, taking it to the next level, it's clear, even in the record that we do have, that there is a loving bond between Marian and the petitioners here.
Absolutely.
I think that's clear, and the court understands that. I guess my question to you is, consent to adoption isn't the same for an adult as a loving bond. You can certainly have a loving bond and have it strongly, but not necessarily say or agree that you want to be adopted. How are we to reconcile those two things?
I think that's where the exercise of discretion comes in and why the statute plainly says the judge
So
can do
are
that.
we saying that perhaps something similar to Bennett v. Jeffries, kind of an extraordinary circumstances evaluation that needs to take place, and then you look at the best interests of the person?
Yes, it is an unusual circumstance. I'm not sure it amounts to extraordinary, but yes.
And-
Look underneath the petition and see it. There was a case out of Chemung County last year where the petition was found to be based on a malicious motive, and that was not, the adoption wasn't allowed to go forward. This is entirely different. There's no evidence that there is any untoward aspect of this family, and Marian has been part of it for more than a decade.
All right, want to change tracks for a moment over here. And it's a statutory interpretation question. So why isn't an interpretation of 111 sub 1 sub A that limits the definition of adoptive child to minor children between 14 to 17, why isn't that the most consistent interpretation with the legislative history that underlies that provision?
I can't explain the operations of the legislature. I don't know.
Okay, fair enough.
Thank you, counsel. Counsel?
Yes, so two things, if I may. I want to address the concerns, the stated concerns that an entire class of people will lose out on the ability to be adopted. And I want to point out that, the risk of adopting out people who are not able to object to that adoption is so much greater. Those people will have all of their family ties, all of their biological family ties cut, and a whole new family structure put in place.
But isn't that true of anyone subject to an adoption? And isn't that why there's a best interest determination to be made in every adoption case, whether it's a child, whether it's an adult?
But Your Honor, there's also consents required in every other adoption case.
But your
Either
rule,
the consents of the parents.
to follow up on Judge Stein's point, your rule, and this is something the court in many contexts has been very hesitant to do, your rule is reading the best interests of the child or adult out of the adoption process, right?
You still get there after you get through the consent. The legislature simply has not
But
put into
you're
place
making
a structure
consent-
to allow something like this to
You're
happen.
making consent a bar to that, reaching that issue. I mean, in your rule, you never get to best interest because you can't get through the consent doorway, right?
Under the particular circumstances here of this vulnerable class of adults who are not able to provide the requisite
And
consent.
why isn't this vulnerable class of adults even more in need of a best interest type analysis than anyone else?
But what they're in need of is protection from being adopted over their objection, or if they
But
may
they
have, they
can
may
object
object,
or
or they may
consent.
not. But we don't know, which is why they need to be protected from their assets being distributed, even during their lifetime, let alone after they've passed on.
And I think that is a legitimate concern, of course, and I thought from this record that that was one of the things that the Surrogates Court went into.
I don't know that there was really very much examination. The examination into the best interest really involved whether or not Marian was going to lose a lot of services that were available to her. She's not going to lose a lot of services. She loses a lot of oversight. She potentially, and her family members potentially, lose the distribution of assets. She also cannot inherit from many of her other family members after being adopted.
She can inherit from her adoptive parents, and again, that's true of any adoption. I mean, there are certainly infants that are adopted possibly from very wealthy families to not as well-off families.
But consents have been given. Consents have been obtained from,
From the parents.
from the biological parents.
Not by the adoptee.
But we're talking about an adult, not a child, and that's why an adult adoptee provides their own consent.
But neither the child nor the adult in this situation is capable of consent.
But she's still an adult, and her interests are still different, and she's still an individual with all of the rights, privileges, obligations of any other adult, and she needs to be able to make those decisions for herself. And if she can't, nobody should be able to impose a new legal family structure on her, all of the legal trappings that come along with an adoption.
So then what, is she then get a guardian? She's not adopted, she remains in this home and has a separate guardian?
She could get a guardian, she doesn't have to. There are many people who don't have, live in these circumstances that don't have guardians, but she certainly can have a guardian if somebody wanted to apply. And through the guardianship statutes that have been put in place thoughtfully by the legislature, there are all kinds of protections there to make sure that her assets are not dispensed with, that she is, getting all of the services that she's entitled to. There's, reporting to the court to make sure that the guardian is following through their duties. They have fiduciary duties.
If I could
much
just quickly
different.
interrupt you, I see that red light is on.
I'm
So
sorry.
right now, your position is based on statutory interpretation. You're not making some argument that the legislature couldn't change the statute.
That's
to-
correct.
To allow for this best interest analysis to apply, as opposed to the result that you described, which is if you can't provide consent, they can't be adopted.
That's correct. If there's a hole, it's a hole for the legislature to fill.
Thank you, counsel.